In this and the next video, I'll be taking you through the various steps that a court looks at when assessing a discrimination case. I will do so as systematically as possible, and as you will see in a second, for that I have sort of devised a flowchart for the purposes of illustration. Now, the two videos are linked. So in this one, I will firstly talk about direct versus indirect discrimination as I go through this flowchart, as well as the prohibited grounds. And then in the following video, we will be talking about legitimate justifications for differentiation. But let me begin with a brief disclaimer. And this is that what follows is quite procedural and quite systematic in a way. And if you think about specific discrimination cases, particularly topics that you feel very passionate about, this might seem very dry and bureaucratic to you. And I get that. There is something to this. At the same time, we are talking about human rights law here, or anti-discrimination law. So these kinds of actions, these kind of claims do require the scrutiny that the law should afford. It should also afford it to the state, to governments, which indeed can have very legitimate interests in pursuing certain actions, and we'll see that in some instances these actions actually geared towards helping certain groups. At the same time, anti-discrimination law has proven to be also, despite its sort of very procedural outlook, a very powerful tool in the hand of various groups. Huge strides have been made, especially in domestic law, but also international law. For instance, when it comes to sex discrimination, for instance, when it comes to race discrimination. And in my view, these strides, this progress is only possible because the landmark decisions that have made this progress happen are in fact the result of these arduous and very stringent legal processes. So let's get into it. And imagine now here you are a judge and you are confronted with a case. So how do you go about assessing it? And the first question that you will ask, and the textbook actually very rightly puts it in front, is there a difference in treatment? Now, what will subsequently become clear is that the two paths actually look quite similar. There are some important differences, but they are not all that different. What they differ in is actually the result at the end of these paths. So if indeed it proves out that the claimant, the applicant who claims that there is discrimination is right, then depending on the answer to this first question, so has there been a difference in treatment or not, the difference here will be whether this is actually a case of direct versus or indirect discrimination. And this will only really become clear at the very end. The reason why we habitually distinguish between direct and indirect discrimination, and at the end of these clips it will become clear what is being meant by both of these terms, is that there is a difference in intent here. So the fact that the question, is there a difference in treatment, tells us something about the intent of the actor. Maybe it's government, maybe it's the employer, it can be all sorts of actors that is engaged in the alleged discriminatory act. And that obviously will make a huge difference when it comes to what kind of evidence is being marshaled to the field by the lawyers. On the one hand, when we talk about intent, when we talk about there being discriminatory action, we'll be looking at the state of mind of the actor discriminating. Whereas if the question to this answer is no, we will be looking at disparate impact. So let's assume for a moment the answer to this question is yes. What is the next question that we ask? The next question that we ask is there a prohibited ground of discrimination that is at play? So what then are prohibited grounds? And again, it's useful here to actually look at the provision and to look at, again, as we did in the previous clip, Article 2.1 of the ICCPR, which mentions them in the second leg of the paragraph, including, and I just mentioned the grounds here, race, color, sex, language, religion, political or other opinion, national or social origin, property, birth, or other status. Many of those grounds, if you think, for example, about sex, if you think about race, if you think about religion, are grounds that make us habitually suspicious. So if there is a difference in treatment here, it will be very suspect. And indeed, in US language and sometimes also in the European language, these prohibited grounds are also being referred to as suspect grounds. So the moment that the court is faced with differentiation, with distinctions being made on these grounds, it is already suspicious. It already thinks that something is going on here, and the scrutiny that follows, and I'll get to this in the third video, is going to be particularly harsh, and only if there are very weighty reasons, and this is indeed the language used, for example, by the European Court of Human Rights, only if there are very weighty reasons can there be a legitimate justification for them. Note that the grounds is actually an open-ended sort of category. So there is also other status. So this is actually a non-exhaustive list. And indeed, this has proven to be very relevant over time, where, for example, the rights of LGBTI persons have come to be included only gradually. And back in the days when the instruments, including the ICCPR, were created, probably most of the states did not have the rights of LGBTI persons on their radar. Another example of an expansion of these grounds would be, for instance, disability as well, which is nowadays considered a suspect ground. On the other hand, talking about particularly property, I'm not entirely sure whether it's considered a suspect ground in all the systems, but despite there being some difference in what the various systems perceive to be suspect grounds, there is some sort of consensus, particularly on these first ones, that they are considered prohibited or at the very least suspect. Now, what happens if the difference in treatment does not concern prohibited grounds? Well, in that case, the state will still have to justify why it did take a particular measure, why there is a difference in treatment, but this kind of justification will be scrutinized much less harshly. There will be a much wider margin of appreciation for authorities and the actions that they have taken. And since this already leads us to the question of justifications, I will end this video here and ask you to continue watching, because in the next one, we go much more deeply into these kind of aspects.